In a new case heading to the Supreme Court, a federal lower court openly admitted that AR-15s and magazines are owned in the millions by law-abiding Americans, but they found that a state could still outright ban them. So let that sink in. A lower court said that even if a firearm is in common use, the exact test that the Supreme Court said is to be applied in Heller and Bruen, they found that a state could still outright ban those items based purely on the judge deciding that they're too dangerous. This case now asks for the Supreme Court to answer a very simple but very critical question. Does the Second Amendment actually protect commonly owned firearms, or does it not, like the lower court said? So in this video, I'm going to be breaking down what's being challenged in this case, why this case, could be the future case that really decides what happens with AR-15s and magazine bans going forward nationwide, and currently what is going on in this case in the Supreme Court, and the fact the Supreme Court is going to consider this case at the end of this month. Now, before we jump into the details of this case, if you want to support the channel, one of the best ways to do that is simply to subscribe. And also, I want to thank one of the main supporters of this channel, which is 1st Phorm. You guys know that 1st Phorm's an amazing company. They're pro-freedom, pro-America. They support the Second Amendment. And also, maybe if you're on a health journey, if you have a New Year's resolution, check them out using the link down below. And if you use that link and you order any supplements, you can get a free 5-pack of protein sticks. Now, in this video, we're going to be discussing another critical rifle and magazine ban challenge that is now heading for Supreme Court conference and consideration at the end of this month on January 23rd. This case is called NAGR versus Lamont, and it's a Second Amendment challenge to the Connecticut law, which categorically bans AR-15 style rifles and magazines that are capable of holding more than 10 rounds. This petition asks for the Supreme Court to decide whether a state may ban firearms and magazines that are owned by millions of law-abiding Americans for lawful purposes, even when a court finds that the firearms are in fact protected arms and that they're in common use. Now, this law in Connecticut prohibits the sale, transfer, and possession of AR-15 style semi-automatic rifles, which they classify in the state as so-called assault weapons. The state also criminalizes the possession and transfer of magazines capable of holding more than 10 rounds. The plaintiffs argue that these laws impose categorical bans on arms that are unquestionably bearable arms and widely owned nationwide and are in fact in common use for lawful purposes like self-defense, training, and then other sporting uses. Now, how did this case wind up in front of the Supreme Court, and how is it now heading to Supreme Court conference at the end of this month? Well, the plaintiffs here filed a federal challenge in a district court in Connecticut, and the plaintiffs filed a lawsuit based on the Second Amendment saying that Connecticut's bans on rifles and magazines is unconstitutional. They sought a preliminary injunction to block the enforcement of these laws, and the district court on review denied the preliminary injunction, and ultimately they concluded that the plaintiffs were unlikely to succeed on the merits. This case was then appealed up to the Second Circuit Court of Appeals back in August of 2025, and the Second Circuit on review affirmed the district court's ruling and denied the preliminary injunction. Now, critical for this case and why it is so unique is the fact that the Second Circuit, that panel there essentially assumed without disputing, and they agreed that AR-15s and magazines here are in common use. Yet still, even though they found that they're in common use, they upheld these statewide bans on rifles and magazines because of some of the rationale that they twisted, and essentially really what they did is they outright defied what the Supreme Court said in Bruen. According to the circuit court, even if the banned weapons are in common use, it may nevertheless uphold the state's ban because Heller, in their eyes, did not really mean what it seemed to unambiguously say, which is that the Second Amendment protects weapons in common use for lawful purposes by Americans, in our nation. Instead, according to the Second Circuit, the Supreme Court precedent does not actually shield these popular weapons from review, and they believe that they could still apply a different standard looking at whether these are unusually dangerous weapons and if they have an unusually dangerous character. In this petition, the plaintiffs then go on to argue that under the guise of performing a search for historical analogs to the challenged statutes, the Circuit Court engaged in an interest balancing analysis that was practically indistinguishable from the intermediate scrutiny analysis, which was expressly rejected by the Supreme Court in Bruen. So this was really a horrible and one-of-a-kind ruling by the Second Circuit. Not only did they admit that AR-15s and the magazines here in question are in common use for lawful purposes, but then they continued to say that it doesn't matter at all, even under Supreme Court precedent. They said that it is up to the courts themselves to determine which items are too dangerous and therefore can be banned. They also directly defied the Supreme Court's Bruen decision by continuing to do this whole interest balancing test and approach, which again, like I mentioned, was at issue in Bruen and was struck down. And in the past, even after Bruen, has been struck down multiple times. That horrible ruling by the Second Circuit has now led the plaintiffs to seek Supreme Court review, and they argue that the Second Circuit's reasoning directly conflicts and goes against what the Supreme Court said in Bruen and really entrenches this circuit-level defiance in a post-Heller and Bruen world. They also bring up the recent promise made by the Supreme Court and Justice Kavanaugh when the whole Snope rifle ban case was denied. They argued to the Supreme Court that the Supreme Court needs to finally step in on this whole defiance issue, or if they don't, the defiance will continue and these types of outright bans will continue and be upheld by lower courts based on their discretion. Now, one thing that I want to mention with this specific case is the fact that it's still at an interlocutory posture dealing with a preliminary injunction. Typically, the Supreme Court denies the type of 2A cases, but we have seen the Supreme Court recently grant review to an emergency case, interlocutory case like the Wolford CCW case. So there is still potential that maybe this case would also get review, but there also is something else going on. I wanted to mention that there are two other cases dealing with a rifle ban and a magazine ban, which are on the final merits. Those are heading to Supreme Court conference this week on Friday. And if those are potentially granted, well, then this case would probably maybe be put on hold, or maybe could also piggyback off of those depending on what happens. Also, the downside is if the Duncan case or the Vermontes case out of Illinois are denied, well, then this one probably would also be dead in the water. Now, in this petition, they argue that Heller squarely held that arms typically possessed by law-abiding citizens for lawful purposes are protected and may not be categorically banned. The Second Circuit, however, held that even if a firearm is in common use, it may still be banned if judges deem it unusually dangerous. Petitioners here argue that this nullifies the common use rule entirely and would override Supreme Court precedent. Also, although Bruen explicitly forbid courts from doing interest balancing, the Second Circuit allegedly engaged in interest balancing under the whole guise of them doing a historical analysis and doing historical analogs, but really that's not what they were doing at all. Really what happened is the Second Circuit relied on some perceived lethality, military features in shootings as a factor to kind of weigh against the Second Amendment. And really, like I mentioned, what they were doing was an interest balancing approach, which again was struck down by Bruen. The petitioners here stress that the historical tradition allows bans only on weapons that are both deemed to be dangerous and unusual. And AR-15s and these standard magazines owned by tens or hundreds of millions of Americans cannot plausibly be described as unusual. In labeling commonly owned arms as unusually dangerous, they essentially argue collapses the constitutional test and is pure just outright judicial discretion and really again goes against what the Supreme Court has already said. The petitioners here in this case argue that this confusion and repeated upholding of bans on the most popular civilian rifles in America demands immediate and emergency Supreme Court intervention and that they need to review this issue. So another critical rifle and magazine ban challenge is heading to the Supreme Court. It's heading to conference at the end of this month on January 23rd. And like I mentioned, there are two other cases which are going to conference this week on Friday. If those are either granted or denied, that will likely also impact the outcome of this case. So we will continue to watch the Supreme Court very closely to see what they're going to do and ultimately if they're going to finally fulfill that promise made by Kavanaugh that they're going to address a rifle and magazine ban issue potentially in a term or two. So as we get more information, as it develops, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.